Can my kids file the deed to my home after I die? I think we need to clarify some risks to this and maybe a better solution. Many of you have seen my viral video, Do Not Give Your Kids Your Home, and a viewer recently commented that they had transferred their home to their kids, but was told not to record the deed until after their passing. I would not advise this. I'm not sure if whom you spoke to was an estate planning counsel. I'm going to get into the ups and downs in a minute. I am 𝗷𝗲𝗁𝗍𝗁 of 𝗳𝗵tti Law. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. If you are seeking assistance in either estate planning or the administration following someone's passing, you can reach out to us for free consultation at 𝗀𝗺planningattorney.com. And speaking of value, we are always here educating everyone on a regular basis. So ask questions and please share so that together we can help some folks along the way. Now, although a signed deed does establish the transfer, as of the date it's signed, right, many states like New York and New Jersey, where I'm licensed, have recording to solidify that ownership and provide other protections against, challenges to that ownership. A deed sitting somewhere in a drawer, may not transfer the home as you're intending to in the future. So I think that's a huge, huge, huge risk. There's also risk of just loss, dispute, right? Rejection. I mean, so many things can happen. And it is still considered a lifetime gift, right? So when you think about the Medicaid front, which we'll talk about again in a second, it's still a lifetime gift, which requires a reporting. It can trigger capital gains, again, because you're gifting the property, right? They haven't purchased it for fair market value and they haven't necessarily inherited it. You've already given it away, even though it's not recorded until later. And, that means that they have your basis, your cost in the home, and when they go sell it later, your kids, they could have a big tax bill for capital gains purposes. I do think often a trust is the best tool to be able to maintain your control over your home, usage of it, right? Being able to live there, avoid access by creditors of your beneficiaries, and provide them with the most protection via both the tax front and giving them a step-up basis at your passing, and also issuing the distribution to them. At least our practice does so in a protected way for the beneficiaries. It's just more secure, flexible, and of course tax efficient. So I would suggest considering a trust for yourselves. And again, it also protects from the house having a lien against it from Medicaid, right? If you've signed a deed and it's not recorded, right, you still own that house. So how would Medicaid then, right, say you don't own the home? They could place a lien on that home. Granted, I understand there's a deed for recording later, but I would almost say that could be a fraudulent statement to Medicaid if you appeal to it and have said you have not transferred your home. So I wouldn't feel comfortable advising clients in that direction. So if you've drafted but not recorded your deed, I would strongly urge you to speak to a specific estate planning attorney. And if you have talked to them and they've given you that advice, maybe get a second opinion. I know your intentions are good. Make sure the plan actually works and meets all of the needs and goals of your family. Again, I'm 𝗷𝗲𝗁𝗍𝗁 of 𝗳𝗵tti Law. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. If you do need assistance in either estate planning or the administration following the passing of a loved one, you can reach out to us for a free consultation at 𝗀𝗺planningattorney.com. We hope you've learned something new here today. Please don't forget, share, and take care. Bye-bye.